Supreme Court under Chief Justice of India, U. Lalit, has been taking up long pending issues at great speed. Some of these are controversial, some have deep constitutional impact, and others could have huge political implications. Today, the top court took up a clutch of petitions that are asking to either repeal or water down the Places of Worship Act 1991. The Supreme Court has now given the central government 2 weeks' time to file its reply to these petitions. Interestingly, the centre was asked by the top court to give its reply in March 2021 as well, but there has been no reply forthcoming. So what is this Places of Worship Act? Why are there appeals to water it down, and what are the implications? The P.V. Narasimha government in 1991 brought in the Places of Worship Act in the backdrop of the Ram Temple movement. It essentially prohibits the conversion of any place of worship from one religion to another. The cut-off date for this is 15th August 1947. Essentially, the status quo as on the day India gained independence should remain. So, a masjid on that day will stay a masjid, a mandir will stay a mandir. The only exception given was in Section 5 to the Ram Janmabhoomi Babri case. Politically, the attempt was to say that let the Ram temple dispute be decided, but that's it. The same argument will not extend to other places of worship. This thought was upheld by the Supreme Court when delivering its verdict in the Ram Temple case, when it said this law preserves our secular values. So why the challenge now? Several petitions, starting with BJP leader Ashwini Upadhyay, are asking for this act to be reviewed. Former Rajya Sabha MP and BJP leader Subramanian Swamy wants the exemption given to the Ram Temple to be extended to specific locations in Kashi, Vishwanath and Mathura. And, of course, there are other petitioners as well. What's the argument here? The petition essentially argues that the 15th August 1947 cut-off date is arbitrary, that it hampers the right of religion of Hindus, Jains, Buddhists and Sikhs. It says that the act takes away the judicial remedy, the right of judicial remedy, and won't give a solution to illegal encroachments prior to August 15th, 1947. The top court will now hear the matter on 11th October, but it's a crucial act because of concerns that repealing it will open a veritable Pandora's box of claims and counterclaims on different religious structures across the country. To understand the impact of this piece of legislation, I'm joined now by prominent jurist Pinky Anand, who's also the former ASG. Ms. Anand, thank you so much for speaking with us today on Beyond the Headline. I'm glad that you're giving us time this evening. I want to understand why these challenges have come about to the Act at this point.
The challenges to this act have come on a number of occasions, and frankly, it came into issue to some extent in Ram Janmabhoomi case also, as you rightly mentioned. So the question of why it is coming to being now because all these issues are there in the forefront, and you're finding disputes relating to Kashi Vishwanath and others which are taking over the entire, the Gyanpith, the entire controversy, Gyanvapi controversy is there. So in view of all that, you do have to look at the law. And in any case, I think today is a regime where we are looking into what is a valid law and what is unconstitutional law. So therefore, this entire situation, because there are a number of claims and counterclaims that stand foreclosed because of the act, and a variety of fundamental rights which have been abridged and violated. And more so, I'll tell you, actually, if you go back to the history of this bill, it goes back to a period when there were only 3 debates, and on the last day the bill was passed in this fashion, considering it concerns the entire secular nature of the country, rights of various people, of societies, of classes, question of fundamental rights. So basically, you really have today, as you find, we are, as a democracy, looking at each and every vital issue which concerns us in the fabric of the country. We want to put things straight. If there is a right, it should be enforceable. And if it has been barred by any law, willy-nilly, at a time when it should not have been, or in a manner in which it should not have been, well, now is the right time to be doing so.
Ms. Anand, but what about the concerns that watering this down and I mentioned that in my opening comments as well, will open up a Pandora's box. Where will it then end? If you don't keep 1947, 15th August as the cutoff, how far back into history will you go? And will we then see just a litany of disputes over pretty much every kind of place of worship? Also, the impact it will have on the secular fabric of the country.
Tamanna, on the contrary, I feel the secular fabric of the country will survive this because you're talking about rival claims of different classes. Ultimately, what if there is an encroachment? If the nature of a place of worship has been changed over because some invaders have come, or because it has been encroached, or because there has been an unlawful activity, or there has been unlawful sitting in on that property, you really can't sustain that. And simply because you will have any litany, as you rightly said, possibly there would be. If there's litany of disputes, well, so be it. You can't forestall anything by saying that there will be litigation and people will come to court. The fundamental right of a party to come to court, the fundamental right of Hindus, Muslims, Christians, Parsis, everybody to come in and say, look, this act of conversion has been wrongly done is something that you can't deny. The consequences of that will only be that the court will decide and adjudicate. Frankly, even in Ram Janmabhoomi, it had been decided by a court. So be that as it may, claims, litigation, fundamental rights of rule of law is something that is available ultimately to all and all.
Absolutely, absolutely. Technically, theoretically, as per the law, those rights are available to all, and concerns over encroachment, etc. But in the context of our politics, currently and over all of these decades, what do you say to those concerns over, opening up old wounds? What about concerns that some say will be, seen within the Muslim community, that now there will be a number of mosques that will be targeted?
The question is, if indeed any unlawful activity has been done in the course of history by a particular class of people, whatever that might be. Incidentally, history has always shown that places of religious worship have very often been converted by invaders, or even during the time of war, because that seems to be the first target, to really convert that position and to make it your own. So just because today it is a particular class which may have been the aggressor, and they will suffer any hardship on that account, I'm afraid that is not a good ground. Why should we have discrimination in favor of any class? You are making a class open and saying this right is available to all, and conversions have been done across. If more have been done by one class, well, they need to stand and sustain the challenge to this position and say, I want my worship place back. I want the right to be able to worship. I have fundamental rights, all of us have. I, as in the people I'm talking about, not me.
Yes.
So you have Article 25, you have Article 26. We have the right under our constitution to manage, maintain. We have the UN conventions ultimately to say we have rights to maintain places of religious worship and to basically have them with us.
Ma'am, how will you go back into history of hundreds of years? Because you spoke about invaders a couple of times over here, and that's the narrative, right? That there were Muslim invaders several hundreds years ago, and they've demolished temples and they've made mosques there, which now have been around for maybe 100 plus years. How will you go back in history time and again? And what if this now extends, because if this law is watered down, it will extend to any kind of religious structure, right? Will you not then also have counterclaims on temples?
You might have. You're absolutely right. This is what I said. If you open this position up, if the Places of Worship Act 1991 passed in an earlier regime is ultimately struck down because of being unconstitutional, then it will open the field for anybody to contest a position of conversion. That will be the ultimate outcome. But equality is the rule of the game. The rule of law dictates that every class has a right. So wherever it comes, it is so done. Of course, you do know that Dr. Swami, incidentally, has been arguing for not the quashing of the act itself as violative, but of exceptions for the Kashi and the Vishwanath and the Mathura temples, as has been given to Ram Janmabhoomi. So these are issues that will be heard by the Supreme Court on 11th of October and decided whether indeed the act fully must be struck down, or there would be any kind of exception which needs to be inbuilt, or as we call it in law, reading down of the law. So these are the various positions that are out in the open. All the parties are before court. Everybody has been arguing one way or the other, and everybody would be considered, and the submissions of everybody would be taken into account when coming through with the judgment. And while we speak, Tamanna, I must say, take the Ram Janmabhoomi dispute. Let's go back a little bit into history. When the matter came to court, everybody said it's not a matter which would come to court, but ultimately it did. And ultimately it sustained itself right up to the last. Ultimately the judgment came. Ultimately the judgment was accepted by all. That is the greatness of the Indian democracy that you have today. Even though there were apprehensions galore when that judgment was to come through, we are all aware about it, and there was so much standby situation that there would be some kind of opposition or the other, and
Pinky ji,
therefore
that judgment also spoke about the 1991 Act, didn't it? It also
but it's
talked about the 1991 Act.
Yes, it did. It talked about the act, but it was arbiter. That act was not an issue. Ram Janmabhoomi was excluded. Section 5, as you
Yes.
rightly said at the opening, Ram Janmabhoomi was excluded. In fact, that's the argument. What was the basis for only excluding Ram Janmabhoomi? You should have excluded all disputes. This is Dr. Swami's argument in any case. This is what I was telling you. So, therefore, what the Supreme Court said in that case would be arbiter and wouldn't be taken into account. And in fact, the Supreme Court today, when hearing the matter, has considered the issue that this is also an issue to be considered.
All right, we'll see where it goes. Just one last point, and I've asked for your view as a jurist, and we've talked about the law of it, but socially, do you think this is an issue that is a priority that needs to be addressed in modern-day India, Ms. Anand? An issue which could potentially lead to strife between communities?
Let me tell you, as a jurist, I believe that the rule of law dictates that you treat everything on a weighing scale. It has to come through, as they say, kara sona. It has to come through in that fashion and come through as a valid law. You have to have that position. If law is going to get mixed up with the concerns of social, even strife, I might say, I'm afraid it will go into a completely different arena. You have to have, ultimately, our consideration is what? As a democracy, let it withstand whether it is valid, lawful, constitutional. Each of the constitutional values has been upheld time and again. And we have ultimately the moral fabric of society, which is inbuilt into this dynamic constitution. It has to withstand that. If it doesn't, it has to be struck down. Whatever may be the consequences of it, for example, you can see in Ram Janmabhoomi, there was a kind of decision to make it valid for all. And concerns of every group was even met at that judgment. So this is another issue. But law must be constitutional. This is our constitution and this is our democracy.
That's an important point you make, ma'am, and I'll just try and get some understanding from you on it, because the Ram Janmabhoomi order took into account the feelings of the people of this country. It was not merely about what the law says. It's about what the social conscience was saying at that point and what most people felt would be right. So in that same spirit, the law also does take into account what the impact of those judgments will be, isn't it?
Well, you have to have a position where the law can take that into account. When the position came to the Supreme Court and ultimately you had diverse interests, it was reconciled after considering not only the social needs or desires of people, but it was done keeping in mind that that was a possibility and that could be undertaken. But it cannot happen in every case, rest assured. These are not possibilities. I wish they could. I wish there would be no litigation. I wish everything was smooth. But the point is, you do have contesting claims. So you do have the courts. You do have the constitution to set the benchmark of how the disputes would be sorted out.
Yep. All right. Thank you so much, Pinky Anand. Always a pleasure to speak with you. And it's important to break down and understand these very complex issues, which sometimes get drowned in by very polarizing comments and hyperbole. At the end of the day, it's about the rule of law. Thanks once again. Now,